Happy Monday, Tuesday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about stereotyping. Cases that should have gone to the Supreme Court of Canada, but didn't. Clinton Mackenzie was an Indigenous man who was spotted by police in Manitoba running through some backyards. The police officer who spotted him had no prior dealings with him, did not know him personally, but was aware of Mr. Mackenzie and aware that he may have been a member at one point of an Indigenous gang, and realized on the basis of this that he could be up to no good, and in particular thought that he may be in possession of a weapon. As a result of that, the police officer detained Mr. Mackenzie, subjected him to a search, which ultimately turned up a gun and some drugs. Mr. Mackenzie was charged with the handgun and possession offenses, and he took his matter to trial. At trial, Mr. Mackenzie argued that he had been unlawfully detained by the police, that because the police did not have reasonable grounds to suspect, other than the basis of information that he may have at one point been involved in a gang, that he was now currently committing an offense, and there was nothing that they saw that amounted to an offense, Mr. Mackenzie's rights were violated by the officer. The court disagreed and found that Mr. Mackenzie had been lawfully detained by the police, ultimately concluding that his rights were not violated and that the evidence was admissible under the Charter. This case raises important issues about the treatment of Indigenous individuals and stereotyping by police. It also raises concerns about the way that individuals who may have previously been involved in criminal activity could ultimately effectively no longer separate themselves from criminal activity, because it suggests that the police having a mere suspicion that somebody has a weapon because they have previously been involved in a criminal act is enough to detain them, search them, and then ultimately subject them to the court system yet again. It prevents people from moving forward in their lives, from changing their state, from not engaging in criminal activity anymore, and from staying out of the criminal underworld. The more that people are subjected to detention on the basis of prior information learned by police that doesn't necessarily have any specific present applicability, and capable of being detained by police merely on the basis of past associations without any evidence to believe or reason to believe that the person is continuing to commit an offense or even continuing in those associations, really narrows and limits the scope of the Charter. This is not something that we should tolerate in a free and democratic society. It is exactly what Section 9 of the Charter is designed to protect. And the decision in this case seems to be at odds with the case in Lee, where the Supreme Court of Canada found that racial profiling amongst individuals was a significant concern, particularly affecting Section 9 rights. So how does the Supreme Court of Canada reconcile not taking this case and not further expanding the scope of Section 9, or at least further expanding the discussion of Section 9 and the drawing of the line as to where reasonable suspicion for an investigative detention exists? This was an important case, not only because it raised these issues of stereotyping and prejudice by police, but also because the interpretation given by the Court of Appeal has the ultimate effect of narrowing Section 9 rights, which is inconsistent with prior Supreme Court of Canada jurisprudence. And this has a potential national effect, and not just a national effect on criminal courts, but a national effect on people who are trying to improve their lives and get out of the criminal justice system. It's unfortunate the Supreme Court of Canada didn't recognize these significant issues that were in play in this case, and hopefully another case comes before them in which they do recognize the important protections that Section 9 of the Charter provides against unreasonable and inappropriate detentions. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.